first thing to know about witnesses is that referees don't allow witnesses other than you and the employer's representative very often, mostly to keep the hearing brief and on point. However, I've had a few hearings where the referee allows questions to other witnesses when the referee believes a witness has valuable information to add. If you want to have witnesses support your case, then you're responsible for asking them to participate and making them aware of the hearing date and time so they can be available. When you submit your appeal, you can include a list of any witnesses you'd like to have available, including their phone numbers. You can also submit witness names and phone numbers prior to the hearing with additional evidence if you need to submit it. A referee might even allow a witness at the hearing even if you didn't provide a list before the hearing, but it's best to submit a list beforehand if you can. If by chance there's a witness who would really help your case and the witness is unwilling to testify voluntarily, then you can ask the referee to issue a subpoena to require the witness to testify. I've never seen this happen, but technically the law allows it. I think the way this would work is you would need to let the referee know that one of your witnesses is unwilling to testify, and then you'd need to explain why the witness's testimony is important. The referee would then decide whether to issue a subpoena, and if so, likely they would continue the hearing to another date to give time for the witness to receive the subpoena. As with documentary evidence, you'll want to have witnesses who have first-hand knowledge of what happened. Otherwise, their testimony will be hearsay and not given as much weight. Another option that I've found to be very effective is submitting a written statement from a witness instead of verbal testimony. This allows the witness to write in advance the points that will be most helpful to you, and it allows you to get the written document admitted into evidence even if the witness is allowed to testify. If you have a witness write a statement, you want to make sure the witness writes the statement legibly and that he or she signs it and dates it. The ideal would be to have the witness sign the statement in front of a notary public who verifies the witness's identity and also signs and stamps the document. If that isn't possible, you can ask the witness to write at the bottom of the statement something to the effect of, "I am writing and signing this statement under penalty of perjury." This shows the witness really means what they're saying in the statement. Keep in mind that you don't necessarily want to tell the witness exactly what to say. Give the person an idea of what's going on with your appeal and what information would be helpful to your case, but let the witness write the statement in his or her own words. It could also be helpful for the witness to write at the bottom something like this: "I have written this statement voluntarily and in my own words." The idea with all these things is that you want the statement to be credible and reliable so the referee trusts what the statement says and can use it as evidence. If by chance a witness who is allowed to testify has written statements or other evidence in the record, then feel free to question the witness about those statements to show either that the witness is being consistent with what they wrote earlier, or if it's an employer's representative, that the witness is saying something contradictory to what she wrote earlier. When you want to ask a witness about documents, you want to establish that the witness understands what the document is and why it's relevant. For example, you might ask questions along these lines. "Mr. Jones, take a look at exhibit number 24. Do you recognize this document? What is it? Did you create it? What is the date on the document? What did you write here in the third line of paragraph 3 on the second page?" And so forth. You want to use the witness to draw out the most important information that will help your case. Now to an important rule. When you're questioning your own witness, you're not allowed to ask leading questions, but when you question the other side's witnesses, you are. So what is a leading question? A leading question suggests the answer you want to get and often requires only a yes or no response. Here are some examples of leading questions. "Didn't you give me a raise last year?" "You never wrote me up for that, did you?" Or, "You were planning to fire me 2 days after I quit, right?" We can change these to non-leading questions in this way. "Did you give me a raise last year? Did you ever write me up for that? When were you planning to fire me?" You want to avoid asking your witnesses leading questions, but you can use leading questions very effectively to make important points when you question the employer's witnesses. Leading questions can help because with the question you identify the specific information you want to get with a response and require the witness to respond directly to your question, which probably wouldn't work if you ask an open-ended question. We can only cover this topic briefly here, but I'll put a link in the lesson notes to a YouTube video about leading questions and cross-examination that might be helpful to you. Okay, one final issue. Even though an appeal hearing is less formal than court, you're still allowed to make objections if you think they're appropriate. For example, if the employer's representative or attorney is using leading questions with its own witness, then you could object by saying, "Objection," asking leading questions. A few other objections that might come up include objecting to evidence being admitted that you haven't been able to review in advance, objecting to questions that call for speculation, and objecting if a question asks about something that is not relevant. Because these hearings are informal, I wouldn't be too concerned about making objections, and I don't recommend making a ton of them. Use them sparingly and only when they're valid. In the end, though, don't be afraid to make an objection if you think it will help your case.